Got real-life money problems? Need real-life solutions? Welcome to the Debt Relief Show with Dwayne Farnsworth and J.C. Cox, sponsored by the Farnsworth Mortensen Law Offices. And now to help you deal with your debt, here are the hosts of the Debt Relief Show, Dwayne and J.C.
Some people say that money isn't everything.
Welcome to the Debt Relief Show. My name is Dwayne Farnsworth and my co-host,
J.C. Cox.
and we're here to talk about debt and debt relief alternatives and bankruptcy. This is technically a bankruptcy seminar. We're doing something a little bit different than what we normally do on our radio show, and that's we have a live studio audience, and those who are interested in personally asking some questions, we welcome to take the questions. Anybody who's watching on the on-demand live video presentation for this bankruptcy seminar, of course, you'd have to come and speak with us in the office if you want to have some questions answered. We're going to approach this discussion today, first of all, with discussing non-bankruptcy alternatives. As we go along, I'm inviting my co-host to interrupt and add whatever I'm forgetting, and I'll return the favor for JC when he's speaking. Non-bankruptcy alternatives. When someone comes and sees me in my office, about a third of the time, they don't even need a bankruptcy. What they need to understand is sometimes they have plenty of money coming in. They just need to slow down and focus and work up a good budget. And when I say a good budget, I use good meaning get out of debt. A good budget, you can determine if you need to increase your income. You can determine if you need to reduce some of your expenses. You need to make sure you understand what your debts and expenses are and what your assets are, for us to be able to do a good debt relief analysis. The options after you've worked up your good budget is maybe you can work with a credit counselor, a debt management plan where you pay money to this debt management company and they send the money out to your creditors over a structured period of time to get you out of debt. My experience has been in the most recent years that a lot of the debt management plans aren't really feasible because they don't have you paying enough to be able to deal with paying everything off in a 48 to 60 month period of time. So be very careful getting involved with the debt management plan without speaking with a bankruptcy attorney first. Another alternative is debt settlement. And debt settlement, let's say that you have $30,000 worth of credit card debt. A debt settlement company would tell you, stop paying your creditors and send money to us. Let's say they ask for $800 a month. The idea is they're going to save that $800 a month for 10 months, so they would have $8,000 that maybe they could make an offer to a creditor that you owe $12,000 to, and they offer 50 cents on the dollar. Now, first of all, they're not doing anything that you can't do on your own. Second of all, you need to make certain that you're not dealing with crooks, because a lot of the debt settlement companies out there really only care about getting the money off of you, not solving your whole problem. Because what usually happens is, before all of your creditors are dealt with in that manner, one of them is going to file a lawsuit against you, and that's when you end up coming and seeing us. The next non-bankruptcy alternative is maybe getting some housing counseling. A lot of times that's the problem that you're facing, and that you can get somebody to intermediate between you and your mortgage company, whether it's a loan modification, whether it's just a repayment plan. There are other ways of avoiding bankruptcy. If you're behind on your car, by the time you figure out what your good budget looks like, there may be some negotiation that we can do with the creditors to get them to just back off so that you have some breathing room. A lot of times folks will come in thinking they need a bankruptcy, but really what they need to do is just defend down the lawsuit that's been filed. So if you have a lawsuit that's been served on you, put this video on pause or stand up right now and leave the seminar, go speak with somebody, show them the papers that have been served on you, because the real risk is that you don't respond timely or you don't respond in the right way, and the creditor or the creditor's attorney gets a judgment against you for default, meaning whatever they alleged is what you're responsible for, whether you really owed them the money or not, whether you owed them more money than what, or less money, I should say, than what they're alleging. There's where JC.
We're always happy to pay a little less.
Anyway, so if you've been served with a lawsuit, if someone's threatening a lawsuit, get in and speak with a legal professional that does this all the time.
And Dwayne, maybe just also mention, what's the one thing we see so often with people that have been served with a lawsuit that they absolutely should not do?
One thing that they should not do is, you've got me here. First of all, don't just bury your head in the sand and ignore it. If you ignore it, did I get it right?
You got it right.
Whew, it took the clue, but
I threw him off with an ad hoc question.
there we go. So yes, don't ignore anybody who's threatening a lawsuit, who's served a lawsuit, hoping that it will just go away. Many, many times clients will come in and say, can they really sue me 3 years after the fact? And the answer is likely, yes. So now, there are statute of limitations. That's beyond the scope of what we're going to talk about here. We can discuss statute of limitations in the office when you come in and meet with us. We offer a free initial consultation, but ignoring a problem in a financial arena usually will come back to kick you in the butt. Can I say that online?
We're online, so yeah, as long as you
The
haven't offended
FCC
anyone here, and I don't see anyone getting up and walking out, so I think we're okay.
Okay, so, there's other debts that are out there. With the IRS, you can negotiate an installment agreement. If you want to understand how that works, there are great ideas that we can give you in terms of negotiating with the IRS. I don't do taxpayer representation for the collection division of the IRS anymore. I used to, but I certainly can steer you in a direction that you might want to go. With regard to vehicles that are threatened for repossession or homes that are being foreclosed on, there are still negotiations for forbearance or different things that you can do that don't require a bankruptcy. We're experienced in non-bankruptcy alternatives as well. Whether we represent you or explain to you how you can handle it yourself, please take advantage of the opportunity to get counsel from someone who's gone through this process before. So this pretty much wraps up this segment of non-bankruptcy alternatives. When we come back after the short break, we're going to be taking a look at some key concepts in bankruptcy that everybody needs to understand. So thanks for joining us, and please stay with us through the break.
Welcome back to the Debt Relief Show. We are here at our bankruptcy seminar. Dwayne introduced us to some debt relief alternatives and non-bankruptcy alternatives. And now we're going to talk about just key bankruptcy concepts, the things that you would need to know and understand if you're looking at potentially filing a bankruptcy. Those that are here with us at the seminar, thank you for being here. Those joining us online, we appreciate you taking the time and hope this information is helpful for you in looking at your situation. The first thing we're going to talk about is one of the main reasons someone files a bankruptcy, if we're looking at a Chapter 7 or Chapter 13, is to get relief, right? You're struggling with debt. And not just struggling with debt, you're afraid to answer your phone. You're afraid that knock on the door might be a lawsuit coming at you. These are things that weigh on you and make it difficult to get through the important things in life. Right, to deal with your family and your children and your family relationships and your job and making a living and providing all those things that really matter in life. And so when you file a bankruptcy, because one of the purposes of the bankruptcy is to get that relief, there's something called the automatic stay that goes into effect. Now that sounds a little technical, so what does that mean? Basically it means everyone has to leave you alone. That's what a stay in the legal context means. Someone has to stop doing something. In this context, it means creditors have to stop trying to collect money from you. They can't try and take property, so they can't try and repossess a car, foreclose on a house. They can't keep calling and calling and calling. In fact, they can't call at all once we file the bankruptcy and that automatic stay goes into effect. So stay means they have to stop doing something. Automatic means it happens automatically. So as soon as a bankruptcy is filed, that stay goes into effect and that relief starts. And that's why when people, even though the process of a bankruptcy may take several months or in some cases several years to actually complete, the relief that you feel because of that automatic stay is immediate. And that's a great benefit and a great advantage to bankruptcy, and one of the things that makes it such a great tool in addressing people in difficult debt situations. And that's really what the automatic stay is all about and why it's there. And I guess that's really about it. I'll quit stammering around and just say that's what the automatic stay is. In our next segment, Dwayne is going to take us through something called the bankruptcy estate, and he'll explain what that means and how it affects the things that you own and why that's important. So when we come back, Dwayne will take us through that, and we hope that you'll be joining us again after the break.
Okay, welcome back to the Debt Relief Show. My name is Dwayne Farnsworth. This is my co-host.
J.C. Cox yet again.
And we're here in a live presentation, video presentation, and as well those who are joining us in studio to talk about bankruptcy and its alternatives. We're discussing the key concepts of bankruptcy at this point, and J.C.'s just finished talking about the automatic stay and the relief that it gives for someone who's got people threatening to repossess their cars, or foreclosures, or garnishments, or lawsuits. And there's really the biggest relief that our clients get when someone comes and hires us is that the judge is going to issue an automatic stay and tell creditors to back off. Now, another major concept of bankruptcy is we start talking about assets that you own. A lot of people, when they come, they want to know, what can I protect? If I file for bankruptcy, what is the court going to let me keep? And those things are called exemptions. What property can I keep? And there's a very specific statutory outline of certain assets that are protected in Arizona and certain dollar amounts of those assets. So the biggest concept that you need to understand in bankruptcy is on the day that the bankruptcy is filed, an estate is created. It's an artificial entity. You're already familiar with what an estate is, or what an artificial entity is, I should say. A corporation doesn't really exist in the real world. The state statutes say that we can have corporations and LLCs and we can have probate estates. When someone passes away, everything they own, with broad exceptions, become property of a probate estate, and that's managed by the executor of the estate. Well, when you file a bankruptcy, the same type of thing happens. A bankruptcy estate is created, and everything you own, no matter where it is in the world, becomes property of that bankruptcy estate. The most important part of bankruptcy is if you have assets and you file for bankruptcy, you list every asset that you own on the bankruptcy paperwork, and it becomes property of the bankruptcy estate. If you don't list it, that doesn't mean it doesn't become property of the bankruptcy estate, but it does subject your bankruptcy to some very critical exposure with regard to the trustee and the judge. Who manages this bankruptcy estate? It's managed by a bankruptcy trustee that's appointed by the court. What goes into the estate? I already said, everything that you own on the day you file for bankruptcy, but also there's three other things that go into the estate. Anything that you've conveyed away within the last 6 years that you didn't get a fair value in return for, and also anybody that you've paid money to in the last year, if they were related to you, that you owed them. These are transfers that come back into the bankruptcy estate, and JC is going to talk about those transfers later on in the key concepts. Now, there's another group of assets that come back into the bankruptcy estate, or not back in, come to the estate, into the bankruptcy estate, and that is if you inherit anything within 180 days after filing your bankruptcy, if you're in a Chapter 7, or during your Chapter 13, if you inherit anything, it will come into your bankruptcy estate as well. So, what is the estate? It's everything that you own, everything you conveyed away that shouldn't have been conveyed away, and everything you're going to get potentially in the next 6 months by someone who loves you, that has money, that passes away and leaves you something in their will. The most important concept of this basket or this estate is anything that you own that is exempt under state law comes out of the basket and you get to keep it. For example, in Arizona, today you can exempt equity in a motor vehicle up to $5,000. Soon, after September 13th of this year, you can exempt up to $6,000 equity in a motor vehicle. If you're physically disabled, you can double those amounts. If you have a dependent that is physically disabled after September 13th, you're also going to be able to take the doubled amount. So what does that mean? If I have a car that's free and clear, a 2001 Toyota Camry that's worth $3,000, my creditors can't take that now. And if I file for bankruptcy, the trustee can't take it because it's worth less than $5,000, and that's what I can exempt. We've provided to everybody here, and for those joining us online, we've provided an exemption list that we will update in early September once that law comes into being. And that exemption list is something you want to discuss with your bankruptcy attorney to make sure that you understand and they understand everything that you have and how they're protected. Typically, what's going to be exempt? Under current law, there's certain household goods that are exemptable. Beds, dressers, coffee table, end table, couch, love seat, washer, dryer. And remember, these are Arizona's exemptions. If you're in another state, the exemptions would be different because it's based on state law. Some states allow federal exemptions, but Arizona doesn't. So if you see something out there online that talks about federal exemptions, generally speaking, you're not going to be taking those exemptions. The great thing about the new bankruptcy law is, or the new state law for exemptions, I should say, is that anything that you have that it's a household item is protected up to $6,500. And when I talk about exemptions, a husband and a wife each individual gets those exemptions. Now there's an exception to that. There is a homestead exemption in Arizona that is $150,000 worth of equity that's protected in your home. And that number cannot be doubled between a husband and a wife. But if you're talking about cars or furniture or electronics, appliances, clothing, these types of items are exemptable individually, and so you can double those exemptions if you're filing bankruptcy as a husband and wife. Property that's non-exempt that you need to be careful about. Personal injury claims. If you've been in an auto accident or somebody owes you something because of a personal injury, you cannot exempt that in Arizona, and you don't want to file for bankruptcy until you know what that asset is worth, and maybe even until you collect that and use that for needs that you have. You also can't exempt or protect tax refunds. So timing of the filing of bankruptcy is very important relative to property of the estate. If you file for bankruptcy and you're still owed a tax refund, or if you've received it and haven't spent it, this is an asset the bankruptcy trustee can take. Now, you don't have to worry about things that are owned by other people in your household. If somebody else owns them, your creditors can't take them from them. But if you have a joint interest with them, then the entire asset is subject to being property of the bankruptcy estate. For example, if you have a car that's worth $8,000 and you can exempt $5,000 equity in the car currently, that leaves $3,000 of non-exempt equity. If you own half of the car, $1,500 of that non-exempt equity is, you know what? I've messed this example up. You can see I'm human. If you own half that car, you own $4,000 of it, and your $5,000 exemption would protect it. So I made up an example on the fly, but I think you can see now how that works. Let's say the car were worth $12,000. You can claim your exemption. The non-filing joint owner of the vehicle can claim an exemption in the vehicle, so there's $10,000 protected, but there's $2,000 that the trustee in bankruptcy could still come and take the car, sell it, give you your $5,000, give $5,000 to your joint owner, and the $2,000 would be used to pay out to your creditors. That's under the current law. Come September 13th of 2013, the new exemption law in Arizona for a motor vehicle for an individual will be $6,000 unless they're physically disabled, in which case it will be $12,000. So I hope you have an idea of what property you can protect based on the list that you're looking at, that you downloaded or that we've given you. And I hope that you have any questions about property that you own, whether it could be taken by a creditor or not, that you'd give us, our office, a call. So we're going to go ahead and close this segment down, but please stay with us. JC, when we come back, what are you going to talk about, JC?
What, am I going to talk?
Yes, you get time.
I'll be talking about some of those things that you mentioned in terms of transfers, things that maybe you think are already gone, but in terms of the bankruptcy, maybe they're not as gone as you thought.
Okay, please join us after the break.
Welcome back to the Debt Relief Show. We're doing our bankruptcy seminar. I'm J.C. Cox, and this is my co-host,
Dwayne Farnsworth.
Eager to speak.
Always.
Dwayne just took us through talking about the bankruptcy estate and property that's protected, property that's not protected, and that's a very important concept. One of the most important when we're considering filing a bankruptcy, or if you're considering filing a bankruptcy, and why you need to get good advice to make sure you do things correctly and you don't potentially lose something that you really, really didn't want to lose. through your bankruptcy proceeding. One of the things that he mentioned was what comes into that bankruptcy estate. We always talk about it in terms of a basket, right? The day you file, everything you own or everything you have a right to at the time you file goes into that basket. For things like cars and clothes and couches, that's pretty easy to understand and conceptualize, because you can see it, you can touch it, you understand that. There are some other items that aren't quite as clear and can potentially create a lot of problems. And that's where we get into this concept of things that maybe you transferred away or sold or otherwise are no longer in your mind yours, but in terms of the bankruptcy, maybe it's not quite as gone as you think it probably was. And there's where we talk about two things. We talk about preferential transfers and fraudulent conveyances. Now, anytime the word fraud comes up in a legal context, it's a little scary. So I'm going to start with that one. A fraudulent conveyance does not mean necessarily that you have done something illegal. All that it means in the bankruptcy context is you transferred something to somebody else, and what you received back was not equal to the value of the thing you transferred. Let's use an example, because that's a lot of jargon there. You've got a vehicle. It's worth $7,000. You're thinking, I'm in some financial difficulty. I've got another car that's in my name. Maybe I don't want to have this car in my name. And so you transfer it to your sister, who needs a car, but she can only pay you $3,000 for it. You're not specifically doing it because you're trying to, be dishonest in some way. You think better not to have it in my name. My sister needs the car. That's all she can pay. You're a good-hearted person. The problem is you gave a car, or you sold a car that's worth $7,000 to your sister. She only paid you $3,000. You did not get fair market value back for that asset. If you then file a bankruptcy, and depending on who you're dealing with, the time frames may change, but you file a bankruptcy within a certain period of time, and the trustee looks at that, trustee can say, I'm sorry, you didn't get a fair value back. I'm going to undo that transfer. I'm going to put the car back in your name, and now it becomes part of that basket, part of that bankruptcy estate, and the trustee could then take it, sell it, distribute out that money to creditors. Or there could be some other scenarios around there, but basically you're on the hook for $4,000 or the car's coming back in. So those kinds of situations are really important to understand going in, so that when you lay out your plan, and this is what we deal with people every day, we get all of those details, we get all of that information, so when we're laying out the plan, we understand what the implications are of filing bankruptcy, because we don't want you to be surprised with that, and we don't want to be surprised with it. That's the concept of fraudulent conveyance. Preferential transfer is related and similar, but it's different. Preferential transfer is when you owe somebody money and you make a payment to them within a certain time of then filing a bankruptcy. If that creditor got more than kind of everybody else does or would get through the bankruptcy process, it means they got more than their fair share. And that's where the term preferred comes in that preferential transfer. They were preferred as a creditor over everyone else. Again, let's use an example. And this is one that we see frequently that comes up. You've been in some financial difficulty, right? You're struggling with car payment, rent, whatever it might be. Your folks or your grandparents wanting to help out lend you some money. They lend you a couple $1,000s to get you through. Something happens and you come into some money, usually a tax return is where we see this frequently. You receive that tax return and you pay back mom because she was so kind-hearted to help you through your difficult time. And then you file a bankruptcy. This is where now, when you paid mom, you owed her the money. She was a creditor. Well, you paid mom $2,000, but you didn't pay Bank of America 100% of what you owed them, or Discover Card 100% of what you owed them. And so mom as a creditor got preferential treatment. And that's where, again, the trustee can go in, undo that, get that $2,000 back, and then distribute it out to creditors. That's the concept of preferential transfer. Now, if you made a $2,000 payment to Bank of America and the trustee went and got it and brought it back in, well, okay, Bank of America's out $2,000 and they'll get a little bit back. Not that big a deal. But when we're talking about mom, that's a little different, right? That's going to lead to some...
No, that's a lot different. Makes Thanksgiving dinners real awkward.
That's exactly. It's, passing the mashed potatoes may not be done quite so friendly after that happens. Because mom's probably already got the $2,000. She used it in just, the course of her life. And now when the trustee comes asking for $2,000 that mom doesn't have anymore, that's uncomfortable. So preferential transfers, fraudulent conveyances. It's absolutely critical that as you are considering bankruptcy, that whoever you're talking to and getting advice from, that they understand how bankruptcy works. This is an incredibly complex area of law and it touches so many things. And while your cousin Lester is a good-hearted person, he's probably not the best one to get advice from. And you also need to make sure if you're talking to an attorney, you're talking to someone who practices in this area and knows the ins and outs of this law so that they can lead you through this minefield to a successful conclusion and you don't get blown up somewhere along the way in a way you're not expecting.
It's a pretty gruesome analogy, but we'll work with it.
We'll work with it. And that's the concept of transfers in bankruptcy and the preferential transfers and fraudulent conveyances. A lot more to it. Encourage you to come in. If you're considering it, sit down with someone qualified. We deal with this stuff day in and day out, and we know this law, and we can help you get to a result that's going to be good for you and good for your family. Our next segment, Dwayne's going to be taking us through talking about different kinds of creditors, what's secured debt, what's unsecured debt, and why does it matter. So thanks for being with us, and we look forward to talking to you again after the break.
Okay, well, welcome back to the Debt Relief Show. I'm your host, Dwayne Farnsworth. This is my co-host.
J.C. Cox.
And if you've been with us for several minutes, you understand why he's wearing the suit and why I'm dressed more casually, because this is the professor of bankruptcy law. Professor Cox is what we call him.
I thought it was because I was too lazy to iron my whole shirt this morning.
Anyway, we just finished up talking about things you don't want to try at home. You don't want to transfer stuff thinking that you're doing something good. Things can be transferred. Assets can be transferred, real estate, personal property, but get some advice on how to do it, because pre-bankruptcy exemption planning is totally fine as long as you do it right and you stay within the bounds of the law. I'm going to reiterate something I said earlier before, though, and that is when and if you have to file for bankruptcy, you have to disclose everything that you own. There was a man I heard about, he wasn't my client, and that man had a boat by the side of his house. It was a very nice boat. I understand it was about a $20,000 boat. When the real estate market crashed in Arizona a few years back, he got in an upside-down situation of about $5 million. So he owed on a piece of real estate down in Coolidge $15 million, and it had gone down from being a $20 million asset to being a $9 million asset, and he ended up owing, you do the math, $5-6 million. And he decided to get creative with his bankruptcy and not list his boat. And the result of that was, when the trustee became aware of it, when the judge became aware of it, the judge dismissed his bankruptcy, denied his discharge, indicated that he would never be able to receive a discharge of that $5 million again. And guess what the trustee did anyway? The trustee snatched the boat and had the authority to do it, liquidated it and paid it out to the creditors. The guy didn't keep his boat, and he can never and forever discharge that $5 million for the debt. He may as well be O.J. Simpson.
And that's why a common question we get when we're talking about, the assets that people have.
How will they know?
Or how will they know exactly?
That's one of our staff's favorite lines, because sometimes clients won't talk to us about that, but they'll ask the paralegal. So how will the trustee know? It doesn't matter how I'll tell you how the trustee know about a boat. There's a registration with the state, okay, or the trailer. With DMV, no, there's registration of the boat, actually. That was a classic dumb move. Now, I'm hoping that the attorney didn't know about the boat, and I strongly suspect that the attorney didn't. But it's not if you fail to list something on your bankruptcy, that's fine. We just amend it. As soon as you remember it, we get it amended on. It's important to try to remember everything, but if it's a material item that everybody would remember they have, then you're going to have a hard time explaining that to the judge that I forgot about my boat, and there's serious consequences. But that's not what I'm here to talk about, is it? I'm here to talk about types of creditors.
No, but it was good information.
Thank you. Okay, so types of creditors that we deal with. First of all, there are secured creditors. Very simply, a secured creditor is somebody you pledged collateral to. A secured creditor on a house, you gave them a deed of trust against your home. Secured creditor on a car, you gave them a lien in your car. A secured creditor on electronics, appliances, furniture, you pledged it as collateral. If you don't pay for it, they can come repossess it. I think everybody understands the concept of a secured creditor, but they get treated differently in bankruptcy than an unsecured creditor does. An unsecured creditor, by definition, is somebody you didn't pledge collateral to, or if you did pledge collateral, they didn't go the extra steps to make sure that they have a lien recorded at the Department of Motor Vehicles, or a deed of trust properly recorded in the county recorder's office. Now, admittedly, that's the rare circumstance, but we need to look into that type of stuff before we declare on the bankruptcy schedules that a creditor is secured. Typical unsecured creditors: medical bills, credit cards, signature loans, utility bills, lawsuits that are filed against you for having turned in a car and there's a deficiency on it, or closed down a business and left leases out there, whether it's a personal property lease, which means something tangible like my chair, or a real property lease, which means something real like our real estate and everything attached to it. Okay, so secured creditors, we're going to discuss how they're treated in a Chapter 7 later on in JC's segment on Chapter 7, and I will discuss how secured creditors are treated specifically in a Chapter 13 bankruptcy, and it's very different, and in it lies a lot of the reasons why someone will file for bankruptcy or not, or why someone will file a Chapter 7 versus a Chapter 13. Secured creditors come in three types. You either agreed to give them the collateral, that's called a consensual lien, or there's a statutory lien, the legislature or Congress made it up, or there's a judgment lien. Somebody sued you and got a judgment and recorded it with the county recorder's office. Most of the liens that we see are consensual liens, like we've talked about. You bought the house and you signed an instrument at the closing that said that the creditor had a deed of trust against the home. Very simply, if you don't pay for the house, they start a foreclosure. You don't catch up the payments on the foreclosure, they sell the home. On a car, everybody understands what repossession is. If you agree to make the payments and you don't make the payments, they have the right to send a tow truck guy out. He probably has 5 or 6 teeth in his mouth and he's packing heat. You don't want to argue with this gentleman, okay? Going back to the automatic stay that JC talked about, a lot of the reasons why people will file for bankruptcy is to have the automatic stay stop a foreclosure, or stop a garnishment, or stop a repossession, or stop lawsuits. A secured creditor is entitled to their property. You can't hide it from them in Arizona. If you're behind on the payment, they demand the car back. If you don't bring it back, there potentially could be some legal consequences. However, I'm talking about leased property. Okay, let's recorrect that. JC, that's your job.
Sorry.
Okay, if it's a piece of borrowed or leased something and you don't bring it back once they ask for it back, there's legal consequence. If somebody's looking for their car that you financed through them and they have a lien on, you're entitled to drive that vehicle around. You shouldn't hide that vehicle. But the consequences aren't as severe as on a piece of borrowed or leased equipment. This discussion, this segment, is on types of creditors: secured creditors, unsecured creditors, and I think I'll just mention real quickly that in bankruptcy, unsecured creditors are broken down into a group that are called priority unsecured creditors. These are usually taxes, child support, spousal maintenance,
Student loans.
no, not student loan,
yeah.
but we're going to talk about debts that can't be forgiven or erased later on, and that's what JC's just so excited about it that it's the next segment that we'll talk about, whether a debt can be forgiven or erased in bankruptcy or not. So thank you for joining for this segment, which is on creditors, types of creditors, secured and unsecured debt. And when we come back after the break, then we'll be talking about, what did I just say? We'll be talking about debts that can be forgiven and erased, or debts that are going to live with you beyond your bankruptcy. Thanks for joining us.
Welcome back to the Debt Relief Show. I'm J.C. Cox, and this is my co-host,
Dwayne Farnsworth.
Glad to be here with you, and glad that you came back with us after the break. Before the break, Dwayne was talking to us about something. What were you talking to us about? Oh, yes, creditors.
Types of debt.
Do they impact people thinking about bankruptcy?
Oh, yeah. Oh, yeah.
Creditors.
Timing.
Have you guys had to deal with creditors from? Okay, all right. Let's make sure it was still relevant to our discussion. I'm kidding, of course. What I'm going to talk about is dischargeability. Well, what in the heck does that mean? Well, why do you file a bankruptcy? Why would someone file a bankruptcy?
Well, you want to get relief from a debt.
You want to get rid of some debt. Well, that's what the discharge is in a bankruptcy. A discharge is an order from the federal court that says these people that you listed in your bankruptcy, as long as they're not in one of the categories we'll talk about in just a minute, these people that were listed, they are no longer legally allowed to try and collect a debt from you. They have been discharged. In simple terms, that debt is wiped out. You don't have to pay it. They can't try and make you pay it. If they ever do try and make you pay it any time in the future, they're violating that federal court order, and there are consequences to them and possibly some benefit to you. But you really don't want to go down that path. You file your bankruptcy, you go through the process, you get your discharge, and that's the relief. In bankruptcy, not all debts are dischargeable. And usually when people ask, well, which debts can I get rid of, it's easier to talk about it in terms of which debts can I not get rid of.
Yeah.
Because all debts are dischargeable unless they're not dischargeable. So let's talk about the debts that you can't get rid of in a bankruptcy, or generally you can't get rid of in a bankruptcy. Dwayne mentioned priority debts. So let's start off with the one that you're not going to get rid of in a bankruptcy, and that's child support and spousal maintenance. If you owe that, you're going to have to pay it. A bankruptcy is not going to get rid of it at any point.
And that's the way it should be. It's a good public policy.
Exactly. And that really runs through most of the reasons these debts are not dischargeable, or why these debts. We also talked about taxes. Well, we know who writes the federal bankruptcy law, and that's the federal government. And we know who imposes IRS taxes, that's the federal government. So they've made sure that they as a creditor are, in most cases, going to be able to get their money back. So some taxes are dischargeable. A lot of times they are not, and it can be complicated figuring out what is and what isn't. Again, that's a case where you really need to sit down with someone who understands the bankruptcy code and the implications of tax debt. But often tax debt is not dischargeable, but it may be. You've got to sit down with someone to find out. All right, so child support, spousal maintenance, taxes, money that you owe for, well, actually, before I go into that category, student loans. This is a very common question. A lot of people have student loan debt, and one of the questions I get a lot is, can I get rid of it through my bankruptcy? The short answer to that, unfortunately, is no. It's possible, right? It's not, it's not impossible to get rid of student loan debt.
But it's not possible either.
But it's not really possible either. It's so incredibly difficult to do, and it's incredibly expensive to fight it because they're going to be fighting you every step of the way.
And if you lose it, their attorney's fees from their downtown attorneys get added to your student loan. If you started off with a $60,000 student loan and you're trying to discharge, by the time you get done litigating it, you could end up with a $90,000 student loan.
Or more.
Yeah, or more.
Those attorney fees from those big guys, they add up in a hurry. So student loans, often we are not, or almost always, we're not going to be able to discharge in a bankruptcy. The other category, so those are kind of the, we talked about child support, spousal maintenance, taxes, student loans.
Public policy.
Right, good reasons for that. Some question on the student loan, but
yeah.
Okay, we'll say good public policy.
Well, the treasurer would bleed to death at this point if taxes or student loans
now that they've executed their takeover of the student loan industry.
Yeah.
True. Okay. The other category, and encompasses a number of different things, but I kind of refer to this generally as you've done some bad stuff and you have some debt, and I'm not talking about you incurred credit card debt or these other things. I mean, you've had a DUI. You have intentionally or maliciously injured somebody or destroyed some property. You have restitution, those types of things, fines to the government because of these kinds of acts. You've committed fraud, been dishonest in your dealings, business dealings. Those kinds of debts are not going to be dischargeable. And generally, because if you incur debt because you're doing bad things, again, public policy, you shouldn't be able to get rid of those debts. You should have to suffer the consequences of those bad acts, kind of thing. Again, that's not because you took on more debt than you could end up repaying sometime later. These are things that, DUIs and physical violence and fraud, those types of acts that we're talking about. So those are kind of generally the areas of debt that are not going to be discharged through your bankruptcy. The other debts are generally going to be discharged. Now, Dwayne talked about secured debt versus unsecured debt. And it's, in terms of dischargeability, it's kind of a subtle thing, but it's incredibly important. When you talk about a secured debt, right, you go buy a car. You have said, all right, you're going to give me this car. I'm going to pay you $10,000. If I don't pay that $10,000, you can take the car. There's really two pieces to that transaction. There's your promise to pay the $10,000, and then there's called the lien, right, that says if you don't, they can take the car. You've got two things. When you file a bankruptcy, you're no longer required to make that payment. So that personal obligation goes away. However, the lien that's out there is not discharged. That does not go away. So if you stop making that payment, even though you filed a bankruptcy, they still have the right, with some limitation because of the automatic stay that we've talked about, but they still will have the right, if they take the right steps, to come take that vehicle because the lien does not go away. So liens don't disappear unless there's some provision under the bankruptcy code that allows us to deal with them. That's really, again, in a nutshell, dischargeable debts, non-dischargeable debts. Again, sitting down with someone who understands the landscape, absolutely critical to make sure that if you're going to file bankruptcy, you're going to get the benefit that you want.
Invading your personal space here. This next segment that we're going to address will basically, I'm just going to talk about why people file for bankruptcy and what bankruptcy is for. And so if you'll stay with us through the next segment, we appreciate you being with us. We're going to take a little bit of a break for those who are here with us in studio. And I stood up and interrupted because we were actually going off of script. We're changing a little bit from what JC and I had decided to talk about next. So thank you for joining us, and please stay back with us after the break. Okay, welcome back to the Debt Relief Show. My name is Dwayne Farnsworth. I'm your host. I'm here today with my co-host,
JC Cox.
You forgot. We're glad for those of you who've joined us in studio. We're excited to be able to have this presentation available on demand, online, for anybody who needs it when they have a need. At the ending of the last segment, I stood up and kind of did an audible, called an audible on this play. We're going to talk a little bit after the break now on a topic that I hadn't anticipated, just kind of introducing before we talk about Chapter 7. I'd like to talk about why people file for bankruptcy and what the purpose of bankruptcy is. Bankruptcy is intended to allow honest debtors to get a fresh start, free from the encumbrances of past financial mistakes. These are pretty much the words of the United States Supreme Court. Something that's really interesting that I found in this last legislative session in Arizona, as I worked with the legislature, I found that the policymakers and the people down at the State House are very concerned about people that are between a rock and a hard place, people that are having trouble financially. So, when we had the vote on the new exemption law and the vote went 54 votes for and no votes against, apparently there were 6 people who didn't show up for work that day, but on the Senate side, 28 votes for, 1 vote against, and 1 non-voting. It's clear in passage of the new exemption laws that protect consumer debtors, that protect normal families and individuals and people, that the state legislature is keen in these tough economic times to help protect the basic needs of the citizens of the state of Arizona. So I wanted to ask JC, kind of as a quiz or a off-the-cuff type of a question. In your opinion, what are the top 5 reasons why people will file for bankruptcy?
Is that on my cue card somewhere?
No cue
Line.
cards. Our survey says.
Yeah, what I've seen with people coming in, people that have medical issues, medical bills, that's a big one. People that have had a reduction in their income or a job loss, some business gone down, the money coming in has been reduced somehow. Other ones that I have seen are because of divorce. That's a bankruptcy and divorce, as if the marriage falling apart isn't hard enough. Now you've got the financial issues that almost always go with it. So that's a big driver. And I think people that have just gotten themselves into a difficult situation and now some kind of, I don't want to say catastrophic is not the right word, but some big event has occurred. There's been a lawsuit. There's been a garnishment that started,
A trigger of some sort.
Yeah, of some sort. That's one. And I'd say the last one of my top 5 is probably people that are trying to figure out how to handle a house that they probably have not been able to afford for a while or just can't afford.
That's a good point. Over the years, my top 5 that I've seen, and you started off with medical, and that is the case. Easily, half of the cases that I've represented in bankruptcy or consulted in bankruptcy, there's been some medical issue. Whether a medical issue that you had to deal with, or whether it's a medical issue of a family member, you lost income as a result of it, or had bills arise as a result of it. I think anybody in this room, anybody watching this can relate to the effect of loss of income or medical expenses related to their financial pressures. I'd add to the list also, over the years, tax problems. Getting behind on taxes and the IRS, or even worse, the Department of Revenue planting the screws down on you pretty hard. Businesses that people have been running, this is one of my big 5, is they've been trying to keep the business afloat, keeping payroll paid, maybe not being able to pay all the suppliers, maybe not paying all the payroll taxes, but as it goes down, failed businesses. And in the economy that we've had in the last 4 or 5 years, failed businesses are more than, any time in my career.
And so I'm going to interrupt you just real briefly there. Anyone watching it out there that's a business owner, you better be very, very, very concerned if you're not paying your payroll taxes, because you want to talk about a debt that never goes away.
Yeah.
There you go.
It's not dischargeable in bankruptcy, and and the Department of Revenue, IRS, they don't play games when it comes to business-related taxes that weren't withheld and paid over.
And they're not just the business's problem. If you're an owner or a manager of that business, they're your problem personally.
Yep. So if you're running a business, having some financial problems, come consult with an insolvency professional just to see what your options are and see what worst case scenario could be. The biggest problem I see with small businesses is keeping the business going too long, because it's my baby. It's right on the cusp of coming back. I've heard that many, many times.
Many times.
Okay.
Entrepreneurs are by nature optimistic, and sometimes that can work against them.
And it seems like there was a 5th one.
And I interrupted you.
No, that's great. And I remember now, I almost remembered. Wait, hold on. Business. We were talking about domestic relations, family and divorce that you brought up. That's a big one. What happens is you're trying to support 2 households on what you could barely support one on before. And you've got counseling for the kids, and you've got court-ordered this, and you've got attorney's fees, which are extraordinary, and you've got costs of the court, and you've got appraisals, and it's just a wicked, deadly time. And very, very frequently, domestic relations or divorce problems go hand in hand with bankruptcy. Bankruptcy is intended to allow honest debtors to get a fresh start. If you'll remember that part, that's the purpose of looking at your options and determining whether a bankruptcy option is as good as or more realistic than one of the non-bankruptcy options that we discussed earlier. So I wanted to make sure we kind of got this before we launch into a Chapter 7 explanation of how it works and what it is and what the process is, the advantages and the disadvantages, pros and cons, that we kind of set the foundation of really who comes and needs to consult with us. And 80% of the time, like I've spoken with my wife or colleagues about, the people I meet with every day are people that I feel very comfortable going out and having dinner with on Saturday night. That's not an invitation. My wife and I like to dine alone. But
I don't even get invited.
But my point is that sometimes there's this characteristic or
Like a stigma.
I'm thinking of, we're both kind of touching on it, but it's a stereotype.
There you go.
Thank you, of who files for bankruptcy, and it couldn't be further from the truth. If you sat with me all week long and consulted with who I meet with, you would see that it's just people just like you and me. So in closing this segment out, I would just invite anybody who needs to get their personal financial spiral from at a freeze or a stop is gather together all your information, set up an appointment with an attorney to discuss what your options are. So we're going to come back in a little bit and really get to the meat of the matter. JC will be talking to us about Chapter 7 bankruptcy.
Welcome back to the Debt Relief Show. I'm your host, JC Cox. This is my co-host,
Dwayne Farnsworth.
Glad to be back with you. Glad you are joining us again to talk about the bankruptcy and some of the things that you need to be thinking about and considering. In the last segment, Dwayne talked about why people file bankruptcy and maybe the kind of people that, or what leads people to filing bankruptcy. And as he said, it's good, honest people, very much like all of us that have just found themselves in a difficult financial situation. I would just add one other thing to that, is that it's so easy to just be completely overwhelmed. And a lot of times that's the position people find themselves in. They're just so overwhelmed, and they would never want to go down a bankruptcy path, but they've just kind of come to a point where they just don't know what else to do. Don't wait till you get to that point. If you've got some questions, you're not sure what the best course of action is, come in and have a chat, and let's talk about what your options are. You don't have to wait until you're almost at the point of feeling all hope is lost to find out what options are out there. I will tell you that almost every time someone comes in, we have an initial meeting. At the point when we stand up and we shake hands and they're about to walk out the door, the comment I almost always get is, I feel so much better. And it's just because we're removing that cloud, that fog of the unknown, and not understanding what might happen to me, what might happen to my family. Just knowing, I'd steal a G.I. Joe line, right? Knowing is half the battle. But it does.
I thought that was Patton.
No, that's me slapping you. But really, just understanding where you stand and what options are available really can remove a lot of that burden. So if you're considering it, come in for a free consultation and let us help you understand what your options are.
Fear of the unknown is an irrational fear, but we all succumb to it. For me, it's when I take my car and drop it off at the auto repairman. And so we all have times where our palms sweat, and to remove those fears is healthy.
Absolutely. Okay, so with that, with my ad there, let's talk about what I'm supposed to be talking about, and that's kind of what the basics of a Chapter 7. What is a Chapter 7 bankruptcy? Chapter 7 bankruptcy is known as a liquidation bankruptcy, and we'll talk about why it has that name in just a minute. But, kind of to follow on with the last segment, why would someone choose to file a Chapter 7 bankruptcy? Well, as we have talked about in some of the other segments, there's really two main reasons to file bankruptcy, and applies to Chapter 7. One is to get some relief, get creditors to back off, reclaim your phone. Don't be afraid of the knock at the door, right? Just to get that immediate pressure removed. That was the automatic stay that we talked about, getting that space to allow the process to go forward. The second thing is to erase those debts that can be erased. And that was the bankruptcy discharge that we talked a little bit about earlier. So that's why we would file a Chapter 7, is to get that relief. Now, filing a Chapter 7, there are some requirements to determine whether or not you can file a Chapter 7, determine your eligibility. The first that we look at is your income. Chapter 7 eligibility is based on how much you make. So there's 2 income tests. You have to pass one of them. One of them is just a straight comparison of your income for your family size to a number published by the Census Bureau. If you're below that, you can file Chapter 7. The second one is a little more complicated. It's a formula that Congress created.
It's a lot more complicated.
That was an understatement. Anytime you talk about something Congress has created, you just know it's going to be complicated. So it is, and we have to get a lot of information from you in terms of your debt and your income and some of the other expenses, that your income and expenses, those things, to determine whether or not you would qualify if you don't pass the first test. But we run through those. Assuming you would pass both of those tests, we also have to look at if you filed a bankruptcy before. Now, technically, filing a bankruptcy before may not affect your eligibility to file a bankruptcy, but remember the main benefit to filing is to get that discharge. And if you filed another bankruptcy in the past, depending on when it was, you may not be eligible for a discharge. So I know getting together on the weekend and filing a bankruptcy can be a lot of fun, but if you're not going to get the benefit, you may not want to do it. So that would be another thing we'd have to look at.
The clerk of the court's never going to turn a petition away at the counter. She's going to clock it in, but you're going to have a bankruptcy in your credit report that doesn't do you any good if you received a discharge in a bankruptcy filed within 8 years of the day you walked into the clerk's office.
If you filed another Chapter 7. So that's an important thing that we look at. It also, in addition to just are you eligible and can you get a discharge in a Chapter 7, we would want to sit down and really understand your situation to determine if a Chapter 7 makes sense. Why would a Chapter 7 make sense? Why wouldn't it make sense? Well, again, the point is to get rid of debt. So we need to understand what kind of debt you have. Is the debt you have dischargeable? If all of your debt is student loan debt, what's the point of filing a Chapter 7 that's not going to discharge your student loan debt? If it's all non-dischargeable tax debt, same thing. On the contrary, if you have a lot of medical bills, credit cards, a deficiency on a car that was repossessed, these are dischargeable debts, and Chapter 7 would make sense. One of the other things that's a very important aspect in assessing a Chapter 7 bankruptcy is what kind of assets do you own? What is the property that you have? Because remember, we talked a little earlier about the basket, the bankruptcy estate, and property that is exempt and property that's not exempt. If you have things that are not protected or not exempt under the Arizona state law, you could potentially lose those if you file a bankruptcy. So how does that work? Let's use an example instead of me just talking in the abstract. You own 3 cars. Okay, you and your wife and one of your children, your son has, you each have a car that you drive. They're not worth a lot of money. Let's say your car is worth $5,000 and your wife's car is worth $5,000, and your son's car, which you bought and titled in your name, is worth $3,000.
What color are they?
White, red, and white.
Okay.
All right, that's an important. No, it's not. Okay. Under the Arizona law, there are exemptions that will protect 2 of those cars. Husband and wife can each protect right now $5,000. September will go to $6,000 of value in those cars. So mom and dad's cars, we could say, okay, they're protected, they are exempt, they come out of that basket. Son's car, which is titled in dad's name or mom and dad's name, technically that belongs to mom and dad. There's no more exemptions for vehicles, so you file a bankruptcy, you either have to know what you're going to do with that car or plan on losing it because the trustee could take it. So that's just one example, but really understanding your assets and what you could potentially lose in a Chapter 7 bankruptcy is important. So property that is not exempt, not protected under the law, property let me flip that around. Property that is protected is exempt, you get to keep. Property that you owe more on than it's worth, there's no value in that as far as the bankruptcy trustee is concerned. So if you owe $10,000 on a car that's worth $8,000, trustee's not going to take that, sell it, and have to pay another $2,000. They only care about money that they can get. So over-encumbered property is somewhat protected in that sense. But the rest of the stuff, the rest of your property, if it's something you stand to lose, then you really have to determine whether a Chapter 7 makes sense in that context with potentially losing that property. And that may be a reason why instead of looking at a Chapter 7, we may look at a Chapter 13. And Dwayne will talk about that in just a moment. So those are some of really the basics in terms of a Chapter 7. Actually, one other point that I would hit in terms of a distinction between a Chapter 7 and Chapter 13 that is an advantage is that when you file a Chapter 7, you have a meeting with the trustee as you do in a Chapter 13 a month later, a month and a half later. And a couple months or so after that, generally, you will get your bankruptcy discharge. So your process from filing to getting your discharge, you're probably talking somewhere between 4 to 5, maybe 6 months. Whereas in a Chapter 13, you're in a repayment plan that's going to last generally 3 to 5 years. So the time to get through the bankruptcy in a Chapter 7 is significantly shorter, which can be a big advantage in terms of moving forward. All right, that's kind of a brief description of a Chapter 7 as with all the topics we talk about, so much more to it. Please, if you've got questions, you need to find out if it's something that fits your situation, please come in and talk to us or talk to someone who's qualified.
Wait a minute, hold on. We are qualified.
And we are qualified.
Talk to us or someone who is qualified.
Or somebody else
who is also qualified.
Thank you for the English lesson. We can help you again. Eliminate that fog, eliminate the questions, and let you know what your options are. In the next segment, Dwayne's going to talk to us about Chapter 13 and some of the same things, why a Chapter 13 might make sense instead of a Chapter 7, and how it can help address some of those situations. So come back with us after the break, and Dwayne will walk us through Chapter 13.
Okay, welcome back to the Debt Relief Show. As if you've been watching the entire presentation, you already know that I'm Dwayne Farnsworth, the host, and my co-host is with us here today.
Still J.C. Cox.
That's right. You notice, it depends on who stands up, who the host is of this program.
That's right.
At the radio show, we also trade off based on who's sitting in the hot seat with all the buttons and whether or not J.C. can turn me off.
That's the one thing I miss the most is the mute button.
Okay. With regard to the Chapter 7 discussion, I hope you have a visual image of this basket because JC touched on some important stuff. On the day we file for bankruptcy, everything you own goes into this basket. So let's just pick a date out of the year. Let's say that on September 1st, we file the bankruptcy. Whatever we own, wherever it's located, whether it's tangible or intangible, goes into the basket. Things that we've transferred away that JC talked about earlier, that shouldn't have been transferred away, less than fair market value, preferential transfers, they come into the basket. Things that you would inherit within 180 days of filing come back into the basket. The stuff that comes out of the basket are your exempt assets, like I talked about earlier, relative to your vehicle exemptions, homestead exemptions, household goods exemptions, clothing exemptions, tools of the trade exemptions, intangible exemptions. These come out of the basket. And also, JC touched on the fact that over-encumbered assets come out of the basket. His example was a car that was worth $8,000 and there was $10,000 owed on it. Or was it a truck?
It was a car.
Okay, good.
I need a new
Was
truck.
that the red car or the white car?
I think that was the white one.
Okay. It comes out of the basket because it has no benefit at the bankruptcy estate. So what's left in the basket at this point? Non-exempt assets that are not encumbered, or at least aren't over-encumbered. And that's why a Chapter 7 is called a liquidation proceeding, because the trustee takes that stuff physically, holds an auction, sells the stuff, generates revenue, and then distributes that money out to your creditors pro rata. So if you have $100,000 worth of creditors and there's $10,000 worth of assets that have been sold, then in theory, every creditor would receive 10 cents on the dollar. Now in practice, we understand that the bankruptcy trustee's office and the bankruptcy trustee's attorney is going to get most of that money. I'm sorry, that's just sarcasm, but I'm jaded in my young age. But the philosophy of a liquidation proceeding is to make available resources equally shared among all of your creditors. And that's the purpose of bringing stuff back into the bankruptcy estate that's been transferred away. It's just a fairness policy. Bankruptcy is intended to allow honest debtors to get a fresh start, free from previous financial mistakes and encumbrance, and to allow for an equitable division of available resources to creditors. All creditors should be treated fairly if they're similarly situated. Now, a secured creditor is treated differently than an unsecured creditor, and a priority unsecured is treated differently than an unsecured creditor general. But if they're a similarly situated class, they're going to be treated equally under the bankruptcy law. Well, that's my 2 cents on our last segment. Now we're going to start talking about Chapter 13. JC, I'd like you to ring in anytime. Chapter 13 is very complex. I love Chapter 13. It doesn't always apply. For my clients, I file more Chapter 7s than I do Chapter 13s. But it's still a great tool that when it's necessary, it's wonderful to have. If you file a Chapter 7 bankruptcy and you own non-exempt assets, what's going to happen to them, JC?
They're going to be taken and liquidated.
Taken by the, but you might need that. That $5,000 vehicle that you have might be what you're using to deliver pizza at night and newspapers in the morning, and you use it to go to your day job during the day. A lot of our clients have 3 jobs, just trying to make ends meet and stay away from a bankruptcy office. So if that vehicle's taken from you, I've used another bad example here. That vehicle's exempt. You can keep that one.
Well, assuming it wasn't exempt.
Okay. Let's assume that I had another vehicle that I used for delivering the newspapers, and if I lost that vehicle, part of my income would go away. So it's real important to look at a Chapter 13 in the context of being able to keep property and pay for it over 36 to 60 months if you would lose it. There's other things that you don't want to lose, something that's been in your family for years. Now, you could sell a shotgun that was your great-grandfather's. If you have a gun that you're exempting and the great-grandfather's gun would be left out, you could sell it to a family member, but you better make sure you sell it for a fair market value. That's kind of hard to determine, the fair market value. So there are times where there's assets that you could lose. One of the biggest things is I don't file Chapter 7 bankruptcies for my clients who are running a business and intend to continue running their own personal small business, because they're on their way to losing not only that business and the inventories and the accounts receivables, but they're on their way to doing some work that 3 or 4 months later the trustee will come back and say, hey, you've been running my business. You didn't have the authority to do that. Whatever you took out of it, you got to pay back to us. So,
And I say it's an important. I think it's a really important element. I don't want to take too much of your time. We talk about that basket, everything you own. If you own an LLC, you own a corporation, that's a thing, and that goes into that basket. And once you file bankruptcy, you don't own that company anymore. Right. The trustee now owns that company, and that's what Dwayne's talking about. You keep operating it, and the trustee can come back and say, all that money you made, that was my company, and I want that money now.
I've seen them ask for gross revenues, not taking into consideration the cost of goods sold or the supplies or maintenance or overhead or anything else. The advantage of a Chapter 13 then is that no one comes and takes your small business. You can continue to run your small business as long as you can provide and pay to your unsecured creditors over the life of your 36 to 60 month plan what they would have received had you liquidated in a Chapter 7. So let me kind of draw an anatomy of a Chapter 13 bankruptcy. Chapter 13 usually takes about 3 to 4 weeks to prepare, unless we have some complicated issues that we want to get worked out before we file the bankruptcy. It could take 2 or 3 months. Timing is real important in the filing of a Chapter 13. Once you prepare a Chapter 13, or how you prepare a Chapter 13, is you provide for arrears that you have on your house if you're behind. Remember, when you get behind on your house, if you're 3 months behind on a $1,500 mortgage, you've got a $4,500 check to write. If they've started a foreclosure, it could be closer to $6,000 check to write. And not many of us can come up with that kind of money. If we were in trouble financially anyway, the reason we missed the mortgage payments, we're not going to be able to write a $6,000 check unless we have a family member or somebody who's willing to help us out. When you're in arrears and they start that foreclosure, you can stop that foreclosure one of 2 ways, either by, well, one of 3 ways. You could sell the house, either a short sale or a regular sale, or you could cure the mortgage arrears, which stops the foreclosure, or if you can't come up with money to cure the arrears, you could file a Chapter 13 bankruptcy, which allows you to cure those arrears, that $6,000, over the next 60 months. Well, that's $100 over the next 60 months. You just have to keep your regular mortgage payments paid and make your plan payment. Now, few plan payments are $100 a month because you usually have a car that you're paying for through the plan. You're paying some back taxes that aren't dischargeable in bankruptcy. You're curing some mortgage arrears. Chapter 13 is great for these types of things. I love a Chapter 7. It's quick, it's clean, it's down and dirty. You might lose something, but it's over. But if it's something you just cannot afford to lose, let's prepare a plan of repayment. It's an adjustment of debts for individuals with a regular source of income. That's the technical title. We just call it a reorganization for individuals. You reorganize your finances, allowing you to focus on first things first. Your housing, your rent, your transportation, your vehicle payment, or your fuel, or your repairs and maintenance, utilities, shelter, clothing, food, insurance. The Chapter 13 allows you to take care of your family's basic needs, and which is left over is called your disposable income, and you use that by paying that to a Chapter 13 trustee every month, and the trustee divides the money up under a court order and sends the money out to your creditors. And the creditors have to come and participate. With a Chapter 7 bankruptcy, with a Chapter 13 bankruptcy, the creditors are mandated by law, I have no idea what that word would have been, are mandated by law to participate, as opposed to the non-bankruptcy alternatives that I spoke about at the beginning of the bankruptcy seminar here, where you're asking creditors that they will settle with you. You're asking creditors that they'll accept a debt management or payment plan. You're asking creditors to wait and work with you while you work up your good budget, get out of debt budget. So Chapter 13 begins by us filing the case. The automatic stay goes into place. What does that mean? They can't garnish our wages. They have to stop garnishing if they are garnishing. They can't repossess our cars. If we do it quickly enough, they might have to give the vehicle back that they've already repossessed. They have to stop foreclosures. They have to allow us to make the regular payments just like we're current, so we don't have to worry about late penalties or interest charges. And we propose this plan to the court. The trustee will look at the plan and decide whether or not the plan meets with the law, and if it allows us to pay enough back to the creditors that the law requires. Early on in a case, there's just like the Chapter 7, there's a meeting of creditors that you have to attend. The meeting of creditors rarely has creditors there. Usually it's just the trustee that's there to ask questions about things they need to know to administer the case. Don't lose any sleep over that meeting of creditors. Chapter 7, Chapter 13, either way, very straightforward. If your case is prepared properly, you have nothing to worry about at that hearing. Once we've gone to that hearing, we propose that plan, we have to begin making plan payments. The plan payments are paid every month. So if we were to file a case on the 8th of the month, the 8th of the following month, the plan payment would begin at the dollar amount that we had proposed. Now, if we need to pay more money in, then the plan payment might change, but they won't go back and readjust the plan payment back for the months we've already paid. It usually takes our offices about 8 months to a year to get the court and the trustee and the creditors to agree to the Chapter 13 plan. That's called confirmation of the plan, and it results in a court order from a federal judge. Most powerful courts in the country are federal courts. It's a court order from the federal judge telling the creditors how they're going to behave and what they're going to receive, and the debtors what they need to pay. Once you've made all your plan payments in the Chapter 13 plan, at the end of the plan you receive a discharge. And that discharge means you own your cars free and clear, no one can come and take your property, the IRS has been taken care of, no more garnishments with regard to debts that occurred, lawsuits that occurred before we filed the Chapter 13. Chapter 13 is a great opportunity for those who have enough money to take care of their needs and something left over to pay something to their creditors. Many of my clients will just say, hey, I know I could file a Chapter 7, but I want to do a 13 and pay what I can afford to pay back. And that's fine, not that they have to. I filed Chapter 13s where we paid everybody $1 on the dollar, everything that was owed. Now that's a very rare Chapter 13, but the reason they wanted to do it was they had enough income to pay everybody back, but they didn't have enough income to pay all the interest and the penalties and the lawsuits and the lawyers and everything that was coming down the pike. And quite frankly, what Chapter 13 allows is a peace of mind going forward, so you can focus on your income and your employment and your family and your relationships and your health, which is good for the creditors too, because if you're healthy and have good relationships and a good work environment, you're probably making more money in most cases, which allows you to pay more back to your creditors. So, with regard to Chapter 13, there are eligibility elements, not as stiff as the Chapter 7 eligibility we talked about before. But you're not eligible to get a Chapter 13 discharged if you filed a previous Chapter 13 that resulted in a discharge within 4 years prior to your filing date. You also are not going to be able to receive a discharge of a debt that was declared non-dischargeable in a previous proceeding. So you can use a Chapter 13 bankruptcy to actually pay that debt out. These are the elements of Chapter 13. I love Chapter 13. It's a great way to get your finances wrapped up into one place with a judge that makes the creditors behave. But if you can file a Chapter 7 and get on with your life, sometimes there's an advantage in that. We're going to take a short break, and after the break we're going to come back and just discuss generally the advantages of filing a bankruptcy and the disadvantages of filing a bankruptcy, and then we'll close out our seminar with a couple comments. Thanks for your participation and your attention, and we'll be back in just a moment to talk about the pros and cons, advantages and disadvantages of Chapter 7 and Chapter 13 consumer bankruptcies.
Welcome back to the Debt Relief Show, our bankruptcy seminar. We have gone through a lot of great information. Hopefully it'll be very useful for you as you're talking about your options. I guess I always forget to introduce ourselves because I think we've already been talking to it for so long. I'm J.C. Cox, and my co-host, what are you now?
Co-host Dwayne Farnsworth, Debt Relief Team at Farnsworth Law Offices.
So, as I said, we've covered a lot of material. Hope it's been very helpful and useful for you to look at your situation, give you some information, help remove some of the fog of the unknown and the mystery there, and help you to see that there really are options that are available out there for you. This is what we do day in, day out. We help honest people get a fresh start. That's what we do, and we enjoy that. We love to work with people. We love to sit down, talk about their situations, talk about their families, their hopes, their dreams, and what they need to do to get over the difficulties they may be facing to get from where they are to where they want to be, so they can focus on the things that are important that we've been talking about throughout the seminar. So what we want to do now in the last segment is just kind of pull it all together and talk a little bit about as far as bankruptcy goes, what are the advantages of filing a bankruptcy, and frankly, what are the disadvantages of filing a bankruptcy? As we've talked about some of the specifics, but just generally, why do it, and maybe why not do it?
I'll throw it out. You can throw it out, and we'll just talk about it. Of course, as we discussed, the main advantage of filing a bankruptcy is that the federal bankruptcy judge has the authority, pursuant to the Constitution, to tell creditors to go pound salt. Okay? Most debts can be erased. We've talked a lot about non-dischargeable debts, but the fact of the matter is most debts that walk into our office are able to be erased and forgiven in bankruptcy.
Very good.
Your turn.
My turn. It kind of goes right along with that, and that's, one of the things that when people come in and they're meeting with us is just the stress that they're under. Mm-hmm. And getting that immediate relief when you file a bankruptcy that comes from the automatic stay, which means, again, it's another court order from the federal court that says, all of you guys, leave them alone. Just back off and quit bugging them. The phone stops ringing. You don't have to worry about them calling you at home, on your cell phone, at the office. You don't have to worry about them taking money out of your account. You don't have to worry about any of these things. It's a huge benefit of the bankruptcy is that immediate relief, and that's the other part of it. It's immediate. Might take a day or two for the phones to stop ringing, but it comes very quick, and that's a big benefit for people that are under a lot of that stress.
Like JC mentioned earlier, I would echo when folks come in to meet me for the first time and we spend 30 minutes, 40 minutes together taking a look at their financial situation, and I explain what relief is available for them, they feel a sense of relief immediately. First of all, because they know there's a plan. All of the fear of the unknown is wiped away to a certain degree, and they know that there's somebody else along with them, that we're there to help them out, and that we have a qualified team to help out. I would say another major advantage of bankruptcy in general, we're talking about 7, 13, is that we can address secured creditors in a way that you can't address without a bankruptcy. You can cure mortgage arrears on a house if you need to in a Chapter 13. You can get into a situation where you can negotiate with a lender on a vehicle that's way upside down in a Chapter 7. Not that they have to, but at least provides the vehicle, bad choice of words, provides the method of maybe having an opportunity to talk to a lender on a car that you owe $16,000 on is worth $4,000. We can just say we're going to surrender that car back and it's yours, and we discharge the underlying obligation. But if you want, we'll agree to pay you $6,000 at X amount over Y period of time, and sometimes they'll come to the table and negotiate. So for dealing with secured creditors, the bankruptcy arena is a great place to go.
Absolutely. One other that I would say is, right, the bankruptcy court, the bankruptcy judges, the bankruptcy system, this is what they deal with. Mm-hmm. They deal with creditors, they deal with debtors, and we're doing it all within the context of those bankruptcy laws. When we first started out, I think the first or second segment, when you talked about non-bankruptcy alternatives, mm-hmm. you get served with a lawsuit, you have the option to defend that lawsuit, which means you're going to go into court, you're going to present your evidence, you're going to do all those things and get whatever result you get. In the bankruptcy arena, for matters that need to be litigated, we can litigate those in the bankruptcy court as well. It's a very good arena to have that kind of litigation because of its specialty, because of its focus, and because it's a court where the judges can really look to the equitable mm-hmm. Solutions. And he would look at fair solutions that if you're just in a Justice of the Peace Court or Maricopa County Superior Court, they may not look at things quite the same way as a bankruptcy judge. So it's a great forum. Now,
I've been practicing for 23 years. I can tell you that the quality of the jurists, those who sit on the judge, are extraordinarily.
People are sitting on the judge?
People sitting on the judge. The judges that sit in bankruptcy court are extraordinarily fair, even-handed. They understand the law, and they apply it very well. And you don't have that always being said about justices of the peace courts or superior court judges. So I'm very, very confident that if I take a matter before a bankruptcy court judge in Arizona, that every judge that sits on the bench is qualified and capable and will come to a fair result. Now, there's certain things in terms of the advantages of a bankruptcy. There's certain things that can be protected in bankruptcy that otherwise are exposed. For example, if you go out and you pledge an exemptable item, a household item, as collateral, in a state court, there's nothing they can do to help you protect that item. But if you're in a federal bankruptcy court, there's actually under Code Section 522, there it is. We've gone the whole seminar without citing a court citation.
Next thing you know, he's going to start talking about the IRS code, and I'm walking out at that point.
Anyway, there's a method for us to be able to protect properties that would not be able to be protected anywhere in a state court action. So those are the advantages, the main advantages that I see of filing a bankruptcy and clearing things out, getting a financial reset. You called it a reboot, a fresh start, a new beginning. Call it what you want. A jubilee, I kind of like that. But those are the advantages. Let's talk for a moment or two about the disadvantages, some things that you ought to be concerned about. So, disadvantage of filing bankruptcy.
Yeah, one of the big ones, and we talked a little bit about it already, is especially in the Chapter 7 context, is the potential of losing property, mm-hmm. right? Things that you own, those non-exemptable assets, property that goes into the basket and stays in the basket, right? There's nothing to pull it back out and say you can keep it. You stand to lose that potentially in a bankruptcy, and that can be a big issue.
But remember, let's say you're talking about a racehorse that you own. Well, let's talk about something more realistic. Somebody has a riding lawnmower. No exemption for a riding lawnmower. If it's worth $1,500 and you file a Chapter 7 liquidation bankruptcy, the trustee's job is to take that asset, turn it into cash, and distribute the proceeds out to your creditors. But remember, bankruptcy didn't cause that jeopardy. If someone sued you and got a judgment against you in state court, justice court or superior court, they can send the constable out or the sheriff out to seize that non-exempt asset. It's non-exempt under state law. So the bankruptcy doesn't create the jeopardy on these assets. It just kinds of brings it to a head.
Normally, with outside the bankruptcy context, creditors, and again, you're absolutely right, the exemption laws that we've talked about apply to any creditor, not just in the bankruptcy context. It's much less common for creditors to go after those kinds of assets outside of the bankruptcy context than the bankruptcy trustee is within the bankruptcy context. But you're absolutely correct.
Another disadvantage of filing bankruptcy is that not all debt is dischargeable. We can't discharge debts for fraud, embezzlement, willful injury, malicious injury, DUI obligation, criminal restitution, child support, spousal maintenance, most taxes, and most student loans.
Wow, that's a downer.
Yeah, I know. But the fact of the matter is, what most people walk in the door with is debt that can be discharged.
Medical bills, credit card bills, deficiencies on cars.
But you have to be careful. So if you get to a point where you think you might want to go on your own for a little while or start making some decisions to maybe avoid bankruptcy, get in and meet with a professional who understands this area, because they can advise you on some pitfalls and some traps and some quicksand that you probably should try to avoid.
Yeah. It's my turn, your turn.
Yeah, let's let me take the low-hanging fruit, and we'll probably close it down.
I knew
at
you were
that.
going to take this next one.
Okay. The disadvantage of filing for bankruptcy, all of us together, is it will dramatically affect your credit. Now, normally I don't care about my credit, because I don't want to borrow money. And so if you do have your credit, your FICO score, your Fair Isaac Corporation score, that falls because you filed a bankruptcy, it's not going to fall as far as you think it would, because you've already got some slow pays and some no pays and lawsuits and maybe a foreclosure and a garnishment. So your credit report is, my clients have taught me this, is usually already taken a pretty severe hit. I'm not going to talk in terms of points, but a great Fair Isaac score is 800. A really good one is 750. You can get by pretty much on anything with 725. If you start having the slow pays and the no pays and the lawsuits, you're going to get busted down to 650, 625. A bankruptcy is not going to drop you another 150 points at that point. Whereas if you had none of this, and all of a sudden out of the blue needed to file for bankruptcy, which is kind of unique, then you might drop 150 points. My philosophy is, or my philosophy was, I didn't care about my credit report. And I will say I've recanted that. I've changed my ways, because my insurance company, for my homeowner's insurance and for my automobile insurance, are deciding whether they're going to insure me and how much they're going to charge for my premium based on my credit ability and credit worthiness.
Right.
So bankruptcy will have a dramatic, devastating effect on your credit report. The bottom line comes down to this. When I advise my clients, I look at the situation and look at it as if it were my own case. If continuing to go along and trying to deal with it myself will not affect my health, my relationships, or my ability to provide for my family, I'm not going to file bankruptcy. But if I'm laying awake at night and it's affecting my health, if I'm arguing with my husband or my wife, or I'm kicking my dog, then that's affecting my relationships. Or if I'm just having things taken from me, resources taken from me that I need to provide for my family, or tools that I need to provide for my family. Now, if my health, my relationships, or any one of the three are affected, I'm going to seriously consider bankruptcy as a better option and not worry about my credit report. Well,
I think that pretty well covers it.
thank you so much for joining us. We hope those who are joining us online have been able to get enough information. If you have any questions, please feel free to give us a call. Those who are here in studio with us, we'd be delighted to stay around afterwards and answer any questions that you have. Again, I'm your host, Dwayne Farnsworth.
I thought I was the host.
Now, when we started, you were. Now you're the co-host. And this is my co-host.
J.C. Cox.
And we'd love to get together and meet with you if you have any questions about debt relief alternatives. Thank you for joining us on this special edition of the Debt Relief Show, the Bankruptcy Seminar.
Thank you.